It is then for the Deputy Chief Justice, in instances where the Chief Justice is unable to act as the head of the judiciary, the Deputy Chief Justice can then perform that function. Members of the court, I submit that the decision in Lina Conchela is good law. And the facts in Lina Conchela are important. When you retire to consider your decision in this matter, you will note that the only respondent in Lina Conchela was the Chief Justice. The only respondent in Lina Conchela was the Chief Justice. If, for the sake of argument, we go along with the submissions made by our learned colleagues for the applicants this evening, that the Deputy Chief Justice then cannot deputize for the Chief Justice, then in Lina Conchela, when a judge of the High Court certified that the issue in that matter was one fit and proper for an expanded bench under Article 165.4, then going by the argument, then there would be nobody to empanel the bench because the Chief Justice was a party. How can he or she empanel a bench in a party where there are respondents? That is the absurdity in the argument by the other side. And my lord, it is our submission, or it is our position, that the Constitution of this Republic must remain elegant, and it must remain functional. Interpretations such as the one urged by my learned colleagues for the applicants, that would lead to that sort of an absurdity, should be rejected by the court. It is my position, as I am on my feet this evening, as I have been consistent, that the Constitution says what it says. But the Constitution only means what the courts of law in the Republic of Kenya interpret it to mean. And it is the interpretation of the Constitution that gives it life, that gives it meaning. And, my lords, my lady, it is therefore my submission that it is a proper interpretation of the Constitution, flowing from the express provisions of Article 161, sub-article 2A and B, that your empanelment was regular. As I take my seat, I wish to submit that I am in no doubt that as you sit as the three judges presiding over this matter this evening, you have no doubt as to the regularity of your empanelment. Because if you did, and flowing from the accolades that have been heaped upon you by learned counsel for the applicants, then you would not touch this file. There are other files that are equally urgent, that deal with the same issue, that have been brought to your attention this morning, this afternoon, and maybe again this evening, where you have said, in the absence of that direction, under Article 165, sub-article 4, you are unable to deal with those matters. So, my lords, my ladies, being satisfied, or you being satisfied with the regularity of your empanelment, this application is for dismissal. And I must add, with costs. So that the important substance in this matter can be determined by the court. I'm most obliged.
My lords, my lady, permit me to just conclude with giving a bit of a context in the Conchela matter. I'm not going to explaining anything because, my lords and my lady, the decision speaks for itself. The decision is a decision of 5 judges of the High Court. In particular, my lords and my lady, paragraph 97 is instructive. 97B in particular, if I may, reads that the exercise of powers under Article 165.4 of the Constitution, though constitutionally underpinned, is administrative in nature. They go on to add that being administrative in nature
the said mandate can be exercised by the Deputy Chief Justice when the Chief Justice is absent, when necessary, or if for good reason the Chief Justice is unable to exercise the mandate. At D, they conclude that in the present circumstances, the rule against bias and the rule that no person shall be adjudged in their own cause dictates that the Chief Justice, being the main respondent in the instance petition, could not assign judges to hear the petition. My lords and my lady, that is the absurdity that learned senior counsel, Professor Guido Mugai, was talking about. Take it a step further. Is it therefore their case that if, as contemplated by their lordships in that matter, if for one reason or the other, the Honorable Chief Justice is unable to perform the functions of that office, is it therefore their case that no matter that requires constitution of a bench will be heard or determined? That certainly would be an absurdity that the law would not have contemplated. That said, my lords and my lady, one of the things that will play out by close of business, these submissions, is that our learned friends from the other side have very deliberately taken to concealing what would otherwise be material information before this court. I say that for two primary reasons. I want my lords and my lady to make reference to their own application, to the grounds supporting the application. They start. The application is based on the affidavit of Honorable David Muja Matenge and other grounds. The other grounds include A, that on the 18th of October 2024, the petitioners herein filed the instant petition together with an application under certificate of urgency seeking conservatory orders restraining the assumption of office by the second interested party pending the hearing and determination of the application and petition. They go on to say that on the same day, the matter was placed before the Honorable Justice Mongo, who considered the matter, and in light of the urgency of the matter and the weighty constitutional issues raised, the Honorable Judge issued the conservatory orders sought in the first instance and certified the matter as raising weighty constitutional issues and referred the matter to the Honorable Chief Justice to constitute a bench to hear and determine the petition. This is where now the story starts. That on the next day, being Saturday 19th October 2024, the petitioners were surprised by the turn of events wherein they were served with the order of this Honorable Bench stating that the first and second respondents' applications dated the 18th October 2024, in bracket the applications for were to be had for their inter partes hearing on the 22nd of 2024. Why do I say there is deliberate concealment of material facts? It is because, my lords, looking at the files that were coming up before this court today, that is E565 of 2024 before the court in Nairobi, and E015 of 2024 in Kerugoya. We immediately, upon learning of the orders that had been issued and which have been adverted to here, filed an application. It is on record. That application, my lords and my lady, sought several prayers. One was that we wanted to have that application certified urgent. Like in their case, our application was certified urgent. Again, we asked that the court considers hearing the application outside the normal court hours. including a possibility of being heard on a Saturday. My lords and my lady, that prayer was not granted by the court. We also, as a third limb of our application, asked that the court considers granting an ex parte order staying the decision of the Honorable Justice Mwongo and the Honorable Justice Mwaita in the Nairobi matter. Again, my lords and my lady, that prayer was not granted. What followed was then the court, as would be the normal practice of that court, gave directions on how this application was to be dealt with. That is how we ended with the date of the 22nd of October 2024. And why this is important, lords and ladies, why is it their case that when they file an application and get orders, it is convenient, it is okay, there is justice. When they get another order in Nairobi, it is okay, there is justice. When we get an order merely certifying our matter as being urgent, then there is, all hell breaks loose. And we are saying, if only our colleagues had sought to present this material before this court, we would not be talking about what we're talking about now. It would have been manifestly clear that we were here on account of an application. My lords and my lady, I've had very strange submissions coming up this afternoon. Submissions including that at the ex parte stage where the court is supposed to be giving directions, the parties expected that the court to have been given notice. Since when, my lords, do the courts in this division, and indeed any other division, attend to matters under certificate, and at the ex parte consideration of those orders, invite parties for hearing of those orders? Why then do we call them ex parte? That submission, my lords and my lady, I repeat, is not for the consumption of this court. That submission can only go to serve an audience that is outside this court, because the people in this court are fully aware of the rules governing the conduct of matters in this court. My lords, allow me a few more minutes just to point out a few other areas which then could speak to the reality of why then the omission of this material fact is then now being used to place this insinuation that the court either did something that was untoward, or the Honorable, the Deputy Chief Justice did something that is untoward. My lords and my lady, at paragraph D, the respondents in the application say, subsequent to the reference of a matter to the Chief Justice on the 18th, the petitioners reasonably expected that once the Chief Justice issued directions on the file regarding empanelment, the petitioners would also be invited for mention before the bench for directions as was directed by the Honorable Judge. If they didn't have an application, on what basis, therefore, was an order going to be issued to them? One would have expected that that would be something that would come from a party not represented. But a party represented would certainly be talking to an audience other than this audience. At paragraph G, my lords and my lady, they say they now have a direct accusation on her ladyship, the Honorable Deputy Chief Justice, say that the Deputy Chief Justice violated Article 1, 10, 27, and 50 of the Constitution in ordering this bench to hear and determine 3 matters in which conservatory orders had been issued against the government of Kenya and its organs, namely, there is no such order that came from a perusal of the file could speak for itself. All that the Honorable, the Deputy Chief Justice did was to constitute the bench. And if anything, this same bench is a bench that had been constituted by the Chief Justice herself. Questions that we ask ourselves. Why is it that when we appeared before this very bench last week on Tuesday, on the hearing of their own application, we sat up to midnight? Today, because it is the issue is on the other side, it becomes irregular. That cannot possibly be a parity of arms when you're dealing with a question of justice. Why is it that when they went all over asking for orders, and this speaks to why there are only 2 matters that came before this court, they filed a number of cases. In those other cases, there were no orders. What business did we have filing applications in those matters? We only felt that we were aggrieved with these orders specifically because the effect of those orders were to suspend a provision of a constitution. And that's why it's important for us that we deal with them. as we seek to deal with them, the only way that the rules of this court establish is that we make an application. And also, my lady, I look at, finally, I think, their ground number L, that they also sought to know the circumstances that led the Chief Justice to delegate to the Deputy Chief Justice. That I think has been spoken to. My lords, my ladies, what then comes out is that if our counterparts had been candid with the facts in the file as they speak, we would not be wasting time as we are right now. We would have had an opportunity to speak to the matters on the basis of the accuracy of the files. We would not be casting aspersions on the court as we have seen. We would not be casting aspersions on her leadership, the Deputy Chief Justice, as we have seen. We will not be casting aspersions on the Chief Justice as we have seen. My lords and my lady, I repeat that submission is meant to achieve two reasons, and two reasons only. One, to delay the proceedings that are before you today. We have an application, and at the right time we'll be seeking and insisting to have it heard. And number two, to then create this negative impression, which I suppose is meant to be used at a later stage. I rest my case.
Thank you, my lords and my lady. My name is Morigara. I wish to submit only on 2 points of law which were actually articulated in support of the application. And these were that the proceedings before this court touch on the Bill of Rights, and they are vitally important that we should actually not be seen to flout the Bill of Rights. The Bill of Rights is Chapter 4 of our Constitution, runs all the way from Article 19 to 50. But I wish to remind the court that the Bill of Rights applies to every party that comes before the court, and it's not just one party. The proceedings we have before the court are very important to the petitioner. They are equally important to the respondents. And it goes without saying that over 50 million Kenyans actually have an interest in these proceedings, and this is the reason why the agency has been certified both ways. My judges, aspersions have been cast on the bench so as to call for this recusal and application of Article 165(4), that you're being drawn into a conspiracy to commit injustice because there is no emergency that requires you to hear this matter as a matter of urgency. Far from the truth, the two applications that are before you to set aside the conservatory order are as important as the applications that led to the granting of those orders. Therefore, the hearing of those applications must be speeded up, and we are able to move with the matter ahead. You've also been accused of being enlisted in service of the violation of the Constitution. Again, far from the truth, because this is an allegation being made against you, while the position of the respondents is that justice must be served expeditiously and as required by our Constitution. Finally, Article 165(4), which uses the word assign and not appoint. Inasmuch as this is a constitutional responsibility for the Chief Justice to assign, it is purely administrative. The word used is not appoint. We are using other words like empaneling and what have you. But, sorry, the word used is assign. And therefore, if the Chief Justice is not able to assign, nothing stops the Deputy Chief Justice from making the assignment. That is number one. Number two, where it is expressly provided in this Constitution that in the absence of the Chief Justice, the Deputy Chief Justice would act, relates to Chapter 9, when the Chief Justice is dealing with the executive. In this